Commonwealth versus Osborne.
Lovell?
Good morning, Your Honors. Amanda Lovell for the Commonwealth. The issue before the court is whether a defendant who has knowingly, intelligently, and voluntarily waived his right to a jury trial nonetheless gets an automatic reversal for the lack of having filed a written waiver.
Well, that was certainly the case in Gallo, was it not?
Well, in Gallo, there were a couple of differences. First of all, it was a different right. In that case, it was a right to be tried by a jury of 12. But on a careful reading of Gallo and the reading that I've done since I wrote my brief, it's clear that the defendant in Gallo personally had nothing to do with the waiver of the jury of less than 12. His attorney did the waiver. It apparently happened in
The lobby?
in chambers, yes. And there's no evidence in Gallo suggesting that the defendant personally agreed to that waiver. They do talk about a written waiver, but again, Gallo was in 1961, and I don't know what the prevalence of colloquies were in 1961, and there's nothing in the record in Gallo to suggest that he had one. It's quite clear that he didn't.
So you're suggesting, for example, that Commonwealth versus Wheeler, which was decided in 1996 by the appeals court,
97, yes.
was also wrong?
Yes.
Okay.
Yes, I'd be asking you to overrule Wheeler, and of course...
But that did deal with it precisely this point, did it not?
Yes.
Okay.
Yes.
But I thought Collado had essentially overruled Wheeler anyway, hadn't it? Not.
Well, it's not what the appeals court found in this case. It is what we believe is the case.
Well, Collado, excuse me. Go ahead, Justice.
What about the Mass Rules of Criminal Procedure?
They were-
Don't they require?
They were violated in this case. There's no question. Well, let me.
And the statute was violated as well.
It appears that they were violated, and I'm not making an argument that they were not, because we don't have evidence to show that they were not. It is possible that the defendant did file a written waiver in this case, or could in another case, and that evidence of that waiver could disappear. That's worth thinking about. I'm not making an argument that that's what happened in this case, because we simply don't know. We can't prove that he filed a written waiver. The statute requires a written waiver. The rules require a written waiver. So the question is not whether there was a violation here. The question is whether what the remedy is for that violation. And we're
So
simply
you're saying
asking.
there was a violation. You don't have anything in writing.
Assuming arguendo, there was a violation,
Yes.
I think is.
Yes. And what we're asking is that the court hold that the violation of that rule be reversal only after a showing by the defendant of a substantial risk of a miscarriage of justice, which is the holding of Collado.
Well, Collado, there was a written waiver, correct? And it was voluntary.
No, excuse me. Yes, I'm sorry.
Collado, there was a written waiver.
Yes.
And it was clearly voluntarily, knowingly, intelligently given.
Yes.
And the issue was whether then he should have been tried separately from others, I guess, who hadn't waived the jury.
That's right.
And the court said that's really a procedural issue that doesn't go to the individual right to a jury trial.
That's correct. Violation of the same statute, which prohibits the trying of one defendant by the court
At the same time that others are
proceeding
tried
yes.
by a jury.
Yes.
Just, well,
Excuse me?
I'm sorry, I'm thinking aloud, and I didn't remember that Collado's was written. It said he asked, but maybe it's in there somewhere.
No, I'm sure it's a written waiver. In Collado, the whole issue was whether the fact that after the waiver was obtained and he was not tried then in strict accordance with the statute, whether that was reversible per se, and the court said no. So it's a procedural issue, and that you would have to show substantial, you'd have to show some sort of harm or prejudice.
I actually don't recall right now whether it was in writing or not in Collado, but the issue wasn't whether it should be in writing, because the procedure violated the statute.
Where there's a statute that I'm thinking of, the alien waiver statute, that simply says that the waiver has to be given. If it's not given, we give a new trial, don't we?
The statute provides a for withdrawal of the guilty plea in the alien waiver, in the alien warning cases.
Does the statute here use the word shall? Shall be in writing?
It is definite. I don't recall if it uses the word shall.
But it is unequivocal.
Yes.
Well, why isn't that the end of it?
Because the question is whether this particular violation of the statute requires a remedy, and they don't always. And in fact, the standby rule is that absent a showing of prejudice, a violation of a statute does not require reversal.
What the statute says, which is partly why at least in Collado, it says Collado asked for and his request was granted, okay? What the statute says, at least I think that's the most recent version, was any defendant in a criminal case, other than whether by indictment, may, if he shall so elect when called upon to plead before a jury has been impaneled to trial, waive his right to trial by jury by signing a written waiver, therefore. Yeah, he may waive it by signing a written waiver, therefore, but that's not quite the same language as, and finding the same with the clerk of court. And that's why I went back to Collado, because it seems to me that what this is saying, because we have such a strong history of a defendant's right to a jury trial, that at least as I read it, waiver of a jury trial, what this is doing is saying that the defendant has the right to waive that. Now, that may be obvious, but it's not quite the same thing. It's not as if it says, you know, when a defendant elects to waive his right to a jury trial, the waiver shall be in writing, which might follow because the legislature determined, you know, there are just too many disputes as to whether a waiver is. And then it says, if the court consents to the waiver. And so all of this is going to, in essence, you may ask and the court may grant.
Your Honor makes a very good point. And
well, I'll just look at the statute.
Well, at the time when this was, when the statute was amended to include the jury waiver portion, it was in 1929. It was not a common thing for, or, well, actually, it wasn't even a possible thing in the Superior Court to waive a jury trial. There was a case in 1926, which is cited in Collado, Commonwealth v. Roe, where the defendant asked in writing to be tried by the court. The court did so, and then Mr. Roe appealed, saying that the court had no jurisdiction. And in fact, this court found that that was correct, that the Superior Court at that time had no jurisdiction. I mean, in 1929, the legislature put in this language, providing the court with jurisdiction and providing a mechanism for which, for the procedural method for waiver.
But since then, we've been very consistent that a writing is required for a waiver. Have we ever said no? It's been raised several times. It comes up from time to time.
I'm not aware of any case. Wheeler is the only case before this one that I'm aware of where it was a jury waiver issue in writing. I can't think of a case where...
Well, I'm thinking of the case that Justice Kaplan wrote that said that a colloquy is now necessary in addition to a written waiver, and without the colloquy, it's no good. All right? So that Kaplan said now there's two requirements, both a written waiver and a colloquy.
Yeah, correct. I would agree that that is what...
See, what I find interesting about your position is there should be a substantial risk of a miscarriage of justice. There are very sound reasons why you want it in writing, and there are very sound reasons why you want the judge to have a colloquy with the defendant, because the consequences of waiving such an important right are profound. And essentially, it seems to me that what the legislature and the court are setting up is you don't want to get involved in endless disputes about whether or not it really was or wasn't a waiver. So looking at it through the prism of a substantial risk of a miscarriage of justice seems to me to be somewhat missing the point. In other words, I could understand if the Commonwealth was saying it's not an automatic, provided that you find, you know, beyond a reasonable doubt that there was, in fact, a waiver. In other words, if the colloquy was such that they left no dispute in anybody's mind, maybe then. But it seems to me that in an abundance of caution, we would want both.
Well, certainly having a written waiver is a good thing. It's good evidence that the defendant knowingly, intelligently, and voluntarily waived his rights. It's simply not constitutionally required for that finding, and it's never been held that it's constitutionally required.
If we looked simply at the colloquy, is it abundantly clear that he waived his rights?
In this case?
Yes.
Yes, it is. When you look at the colloquy together with Judge May's affidavit regarding what his usual procedures were at that time, it is abundantly clear, yes.
And what's the issue about, the dispute about whether the transcript of the judge's colloquy is complete?
I think that I think that Judge May resolved that question. I believe his affidavit refers to what I don't believe his affidavit refers to what his usual procedure was, and then that he went on and asked the questions as reflected in the colloquy.
But I mean, there's no broken tape or garbled sound or.
There's no tape in existence at this time, as far as I've been able to find, and that goes to the period of time between when the defendant was convicted and when he raised this claim.
So what we have just the judge's affidavit.
A portion of the colloquy.
A portion of the colloquy. There is a transcript.
That's what I thought, and that
Yes.
comes from where?
It comes from a tape that existed at some time.
Okay.
But that at some point, presumably between 1998 and 2002, was destroyed by it was destroyed by the court. That the court told me that.
If you listen to that tape, as we know, quite often when you listen to the tape, it's clear that the proceeding is continuing, but we get things like garbled or unclear or indistinct. Is it that, or does it just come to an end?
I don't know the answer to that. I don't know whether it's simply where it's a case where the person transcribing it accidentally did not rewind it all the way to the beginning.
Oh, so we only have
the beginning is missing.
We only have the written transcript.
Right.
That's right.
Okay. I'm sorry.
You rely a lot on Collado, but let's go back and talk about Collado for a second. I was reasonably persuaded by the brief filed by the defendant, because on that point, the Collado, the provision that was violated, and as I understand it, in fact, if you want to waive your right to a jury and have a jury waive trial, but your co-defendants do not, the court cannot permit the waiver. There can only be one trial, and it has to be a jury trial if any of the co-defendants assert it.
Correct.
So that was Collado.
Unless the court decides to sever. But there cannot be, under the statute, a combined trial as there was in Collado. Correct.
All right. Well, what the court said is that this all or none, I thought it was an all or none provision. It has to be a jury trial or a non-jury trial. There can't be two trials.
No, or else the judge must sever the cases. That's what Collado says.
Yes, and I think it actually says, either Collado or the rule says, essentially in an extraordinary case, that simply because some want to be tried by a jury and some by the bench is not sufficient reason to sever.
Well, the court said that this jury waiver provision, this particular aspect, did not vest any personal right in criminal defendants, but was intended to reduce the strain on court resources. Yes. Where surely the requirement that the waiver be in writing very much is intended to protect a criminal defendant.
Well, it's intended to protect the record of the defendant's waiver. And in 1929, it would have been the entire record of the knowing, intelligent voluntariness of the waiver. It's certainly, as I said, it's certainly good evidence that he understands and has knowingly waived his constitutional rights. The question is whether...
It's not only good evidence, but it has been required by statute forever.
Yes. Well, forever meaning at a time when there weren't colloquies taking place, and so it was the only thing at that time. And the only thing, presumably, in 1961 at the time of Gallo.
Can I ask why one wasn't obtained here?
Why there was no...
Isn't this routine? I mean, I don't understand what happened here. Maybe we don't know what happened here.
We don't know.
Okay.
And we might know if we had the rest of the transcript. There might be reference to a written waiver, or we just don't know. We don't know whether in a busy district court it was just overlooked by everyone.
We don't overlook statutory rights, even if the district court is busy. Ms. Dovell, I think I understand why you went on, substantial risk of a miscarriage of justice because that's what Collado does, but that
Yes.
makes sense in Collado, right? I frankly don't think it makes any sense here.
Well, the standard that Your Honor suggested, showing it beyond a reasonable doubt, would certainly be better than automatic reversal.
Okay. Thank you, Ms. Howell.
Thank you.
Ms. Laird? Or was it Reardon?
Good morning, Your Honor. It's Deborah Reardon of Mr. Osborne. Excuse me. The legislature has spoken about the procedure to be used when a defendant waives his jury trial, and that procedure was violated in this case. There's no evidence on the record that a jury waiver existed at the time that Mr. Osborne waived the jury trial.
What do you mean that a jury waiver existed?
That the written jury waiver existed. There was no piece of paper in the file.
How does this come up, by the way? Maybe I've forgotten something here. There was a jury waive trial?
There was a jury waive trial.
With a colloquy. With a colloquy.
Yes, there was a colloquy. The extent of the colloquy is in the transcript. Judge May did file an affidavit when Attorney Lovell tried to recreate the record, I believe the year before last, about what his practice was at the time, or what his practice was regarding colloquies with defendants. However, his affidavit doesn't say when he started the practice, it doesn't say when he ended the practice, and it doesn't say that it was his practice to conduct a colloquy in that manner when Mr. Osborne's colloquy took place.
Now,
so I would submit that even his affidavit is not adequate to represent his past practice.
Doesn't the alien warning statute say that if the warning is not given, he can withdraw the plea? Doesn't it affirmatively say that?
I believe that it does.
And this statute doesn't say anything like that.
No, the statute does not provide a remedy.
So, query whether we should go ahead and make it like the alien warning statute.
Well, this statute was enacted by the legislature to protect the defendant's rights. He has a constitutional right to a jury trial.
That's correct.
And so this statute was enacted to protect that right. It is for the defendant's benefit. And if the legislature obviously didn't enact a statute with the intent of having no
it's pretty clear.
It's
pretty clear he knew what he was doing, correct? We had the colloquy. Nobody's quibbling with that. He understood he was giving up his right to a jury trial.
Well, I would submit that the colloquy was inadequate. That the defendant has not agreed that the colloquy was adequate. The colloquy does not reflect that the judge talked to the defendant about the difference between a jury trial and a bench trial, and how the judge would be hearing the evidence, deciding the facts of the case in a jury waive trial, and deciding the case, versus a jury trial where the jury hears the evidence and listens to the witnesses.
But you're not are you arguing that the colloquy is defective, and that's a separate reason to sustain the appeals court?
In one of my last arguments, I did argue that if arguendo, a written waiver is not required, which I do not agree, that the case law and the statute says that the colloquy itself is inadequate.
All right. So you've got both points.
Yes.
Okay.
Again, I think the substantial risk of a miscarriage of justice is not helpful here. But if it were the case that it is clear at the highest level beyond a reasonable doubt that the defendant has waived, is there any reason, I mean, I can understand why it's advantageous to have it in writing, but if anything, I think if you read the opinion where we established the colloquy, it was because the writing really was not sufficient to inform any fact finder that this was a knowing voluntary waiver. So it seems to me that if you have a full colloquy, and I'm not suggesting, I'm leaving aside whether this is a full colloquy, that if you have that, clearly on the record with no dispute as to what happened, to say that there should be an automatic reversal because you don't have the written piece seems to me to be going about it the wrong way around. I would feel more comfortable if you had the written piece and you didn't have any colloquy to say that may not be adequate. But here, if one had a full colloquy, unquestioned, satisfied, every T crossed and every I dotted, what's the harm to the defendant? I understand the statute implies that it shall be written, says that it shall be written, but as I pointed out earlier, it doesn't say it shall be in writing.
The statute does not say it shall be in writing, but the rule that goes along with the statute, Rule 19A, says that...
Well, that mirrors the statute. It says...
it says that a defendant will be tried by a jury unless he submits a
waives
written
a jury
waiver.
trial in writing. Unless he waives a jury trial in writing, but that, I would say that the careful drafters of the rule conformed it to the statute.
And they did that for a reason, Your Honor, because the writing is required. If I understand what you're saying about a colloquy, and if you have the most perfect colloquy in the Commonwealth with the defendant, and you substitute that colloquy to prove voluntariness of the waiver when there is no writing.
I'm not substituting it because the writing says nothing about voluntariness.
But if in a case where there is no writing,
Right,
if
and
you
I've got
look
a
only
full
to, you look to the colloquy, in
I'm
your
asking-
example.
I'm asking you, what's the harm to the defendant? I know that the statute hasn't been complied with, but that's, in that respect, what is the harm to the defendant?
Well, the harm to the defendant is that his rights were violated by the statute not being followed.
It's an ironic question, actually, because we have concluded that a colloquy is not constitutionally required, nor, I think the argument is pretty persuasive, that a written waiver is not constitutionally required. Both of those, however, one court-imposed colloquy, one statutorily imposed waiver, are required currently. But it would be ironic to say that the statutory rule should not have a remedy of reversal, where the court-created rule, which is not constitutionally based, should. A violation should result in reversal. That is a little ironic, I think.
Well, they did that in Paveo. There was no colloquy in Paveo before the trial was concluded. The judge realized after the trial that there had not been a colloquy, and there was a written waiver in that case, and the court reversed.
Right.
So I think you're absolutely correct.
It would be ironic to say, no, our court-ordered interpretation requires reversal, whereas the statutory mandate does not.
Yes, you get into the separation of powers. And
There's no separation of powers. If you read Justice Kaplan's opinion, what he's saying is, in the aid of sound judicial administration, you need the colloquy, but he's explaining at some length why a colloquy is required. I frankly don't see any irony. I think that one could, I would suggest, look at a colloquy that hadn't been given and decide that perhaps that isn't required, or you could look at the writing and say that isn't required, but it seems to me that as between the two, as indicative whether it was fully informed and voluntary, which a written waiver doesn't have, a simple signature, that I am having a little difficulty understanding if you have a full colloquy, no question that it's an accurate transcript, no question that he was represented by counsel, no question that he was fully aware of everything, and the judge does an admirable job. Why, other than, from a public policy reason, you want to make sure that it's in writing, how the defendant has been harmed in any respect. I don't look to the trial. I don't look to whether there's a substantial risk of a miscarriage of justice.
well, if you just look to the colloquy, there is no, and I'm not suggesting that there should be a script to use for the colloquy. The courts have said that we're not going to give a script for the colloquy. The judges will conduct their colloquies in the manner they think is best, which leaves wide open the question of what an adequate colloquy is, especially in light of the fact in your scenario that there would be no written waiver.
Well, I
If
think
the judge is going to give do a stupendous job with a colloquy, then he ought to include a written waiver in. The legislature requires it.
Well, Ms. Reardon, when you boil down your position, isn't your position that the statute and the rule require a writing, and that's the end of the story? Without the writing, you want us to just enforce the statute and the rule?
It's ineffective without the writing.
Isn't that your position?
It's ineffective. It's as ineffective without the writing as it would be without a colloquy, as in Paveo. If Paveo, the lack of a colloquy in Paveo requires reversal, then certainly the lack of a writing requires a written waiver requires reversal as well.
Does the statute or the rule say that there should be an automatic reversal?
No, they don't address that, Your Honor.
And the explanations in Paveo, as I recall, go to a somewhat different point. They go to whether or not it can be determined whether or not it was voluntary, which you can't tell from a writing. A writing will tell you whether the defendant is exercising his right, statutory, not statutory right, to waive. If it is absolutely abundantly clear and unquestioned from the quality, from the colloquy, that he did in fact waive it, it seems to me that that's a different question than the one that was presented to the court in Paveo.
Well, I would suggest that the court has seen fit to add a colloquy to the writing, not substitute the colloquy for
That's
the writing.
correct. There's
That's
no
what, that's
question.
what Justice
There's
Kaplan
no
said.
question.
We now have two
They're
requirements.
supposed to work together to ensure that the defendant himself waives his right to a jury
Yes,
trial,
and
and
then
he
we
does
get
so
back to Justice
voluntarily.
Blaney's question. The legislature has not specified a remedy. No question that it was violated. The question is, what's the remedy?
Well, there are many cases where the legislature enacts a statute and then is silent as to the remedy.
Of course, yes.
And it's totally appropriate for the court to carve a remedy that they feel is appropriate, and the court has done that. The court did it in Gallo, where even in 1961, the issue in Gallo was a juror that had to leave the trial before the trial was finished, so they had 11 jurors instead of 12. Now, the defendant was not involved in the waiver of that, the full panel of jurors. However, they required reversal in that case because it's the defendant's right to waive the full jury, and it was not done properly. If a writing is required...
I take it as I read, and I read Gallo the other day, and I unfortunately don't have it in front of me, but I take it the defendant could have waived the jury of 12 and gone with the jury of 11, but did the statute require that such a waiver had to be in writing?
I believe that it did.
That's right. I thought so.
And I would submit that if the court reversed in Gallo because the defendant did not personally waive the jury of 12 in writing, then certainly when a defendant waives the jury completely altogether, there should be a writing and a colloquy.
But in Gallo, the defendant didn't even waive orally.
That's correct.
The
He did
trial,
not.
but his lawyer did it.
That's correct, and that was an error as well. I would submit the substantial risk of miscarriage of justice standard is just not appropriate here, that I would reiterate that the part of the statute that addresses the jury waiver is drafted in the defendant's best interest. It's in his behalf. It's his right. When in the Collado case, though that the issue of the waiver was also concerned with the timing of the waiver by one defendant. He executed a written waiver of his jury, but the jury had already been impaneled. The second half of the statute says that the defendant can waive his right to the jury before impanelment, but that both co-defendants have to waive the right, or else a trial takes place unless the judge sees fit to sever the case. As far as the delay goes, the trial took place in October of 1998. The notice of appeal was timely filed after that, and it took 3 years to assemble the record.
Can you explain that for us? Do you have any understanding of that?
I cannot explain that at all. I wish I could.
This is not a very extensive record, is it?
It is not. It is very short.
Did the defendant seek a court order expediting the transcript?
The transcript was prepared shortly thereafter, after the notice of appeal was filed, but the record was never assembled by the
Oh, so it was not a
trial court.
transcription problem?
I don't believe it was, no. I don't have the,
That's all right.
but I believe the transcript was prepared in a rather timely fashion. I cannot explain the 3-year delay. And then, for another unknown reason, when the Committee for Public Counsel Services appointed an appellate attorney to take the case, he never filed an appearance, he never filed a brief. There was a motion to vacate the appeal, which was allowed. I came on as subsequent counsel and got the appeal reinstated. So the defendant should not be held to be responsible for that 3-year delay in sending the case up to the appeals court. Thank you very much.
Thank you, Ms. Levy.
Can we do one more?